All right, as promised, this is not being tested, so I'm going to give you just kind of a very quick overview. We're going to start with the courts, even though they were made last. But the judiciary, they review the acts of Congress and the executive branch. Um, they are expected to have knowledge and objectivity to examine individual situations and to determine what appropriate legal standards are and how they should apply to that particular case. That is what is meant by somebody saying the letter and the spirit of the law. Provide access to the governmental system for the entire population, and it is designed to provide fairness and enforcement of rights of all persons, even though it doesn't always feel that way. So let's talk about the purpose and the effect of judicial law. Um, Interpretations of statutory and administrative law, they will occur anytime that a statute or an administrative regulation or decision is an issue. And the statute and the facts of the case are going to be reviewed. And again, the applicable legal standards will be used to determine the result. There are no two cases that are exactly alike, but a judge may apply the same ruling that's used in a previous case that could have like striking similarities, such as like the facts of the case or the legal issues involved, or even both. But in cases where there is no applicable statute or administrative law exists, then a judge is required to establish the law. And that can be done by looking to the case, the precedents of past similar cases, and applying the principle of stare decisis. Okay. Now, when there is no prior judicial precedent or applicable like statutory or administrative law exists, then the judge creates that legal standard. And that's known as common law. And it's a term that has carried over from the medieval times when judges created the law for the common man. And technically, common law is defined as a newly established legal principle, whereas case law is the application of stare decisis, which means to kind of perpetuate and continue the application of the previous legal principle. So, in actual practice, the terms common law and case law have come to kind of be used interchangeably, but the basic concepts is that the terms represent judicially created law. Now, individuals looking at existing case law in relation to their own situations, by comparing the established precedents, people that are involved in lawsuits can often kind of predict with some kind of certainty the likely outcome of their case. And in doing so, through the process known as legal analysis, they can make intelligent decisions about whether to pursue, whether to settle, or whether to dismiss. I meant to add on the other one that there is a second function to the judiciary, and that is to protect and uphold the law that is consistent with the Constitution. But I'm not going back and doing that whole thing again. So we're just going to move on and pretend that it was on the last slide. Now, the structure of the judicial system. So federal and state courts, they consist of two basic types of courts. You have the trial and the appellate. The trial court is the court in which the case is presented to the judge or the jury. In the trial court, each party, they're going to follow certain required procedures. They're going to prepare evidence, and it's supposed to be for a fair and complete presentation. Then the judge, in many cases, even a jury, they're going to hear the evidence to support the claims on both sides of the dispute. And when this is completed, then a verdict is given that's going to declare whether or not the defendant is at fault for the violation of the legal standard. Now, a court that hears the trials is known as a court of original jurisdiction. And this is where the case is determined for the first time, hence origination or original. So if a party believes that the trial court verdict is the failure or is the result of failure, rather, to properly follow legal requirements for the proceedings, then that party may choose to appeal the verdict. When the case is brought on appeal, then the judges of an appellate court will review all or part of a trial court's proceedings. And the appellate court has the authority superior to that of the trial court and has the power to change the court's verdict. The appellate courts will often consist of several judges who are going to review the cases as a panel. And by utilizing the panel or the multiple reviewers, there's supposed to be less of a chance that mistakes will be made in the review of an application of law in that particular case. The duty of the trial court is to determine the applicable laws, to hear the evidence, to render a verdict, whereas the duty of the appellate court is only to review what took place in the trial court and to determine whether or not the law was correctly applied to the evidence that was presented. The appellate courts will generally not hear any kind of new evidence, whether testimony of witnesses or anything, nor do they tend to issue new verdicts. They affirm, which is approving it. They will reverse it or reject it, and they'll kick it back down to the lower court in that case. Sometimes with, instructions to do something different or whatever. But, and it can be in part. It can be affirmed in part and remanded in part, all of that. Now, the federal system, it started with a single court, which is now known as the U.S. Supreme Court. And over time, Congress has added several courts to the federal judicial branch. And currently, our federal system comprises of 3 levels. Each of them, function totally independent of the state courts, just as each state judicial branch functions independent from, the other states. An easy way to distinguish a federal court from a state court is by the court's name. All federal courts will have the words United States or U.S. in the title. Now, of the 3 levels of federal courts, the trial courts is where the bulk of everything goes, okay? And those are the U.S. district courts. And generally, the U.S. district courts are used as trial courts. There are certain situations where a federal case can be initially heard by an administrative hearing with the executive branch, and then it gets appealed to the U.S. District Court. And in those cases, the district court takes on appellate authority rather than its usual original jurisdiction. There are highly specific types of cases that may be initially filed for trial at the appellate level and that bypass a U.S. district court altogether. But typically the appellate level is reserved for parties who wish to challenge the decision of a U.S. district court. Now, such appeals, like it's made to the next level, which is the U.S. Court of Appeals. And then following that appeal, the party who's still dissatisfied with the result can go up and ask for appellate review by the U.S. Supreme Court. Trying to think. So currently we have more than 90 U.S. district courts, and Congress has increased the number of these courts when I guess it was warranted by the number of cases that have gotten filed and tried in the federal system. So when the burden becomes basically too heavy for a court, then Congress will create an additional court to kind of handle part of that load. The various U.S. district courts, they are separated by geographical boundaries, and legal disputes over federal law that occur or have connections to the court within the court's physical boundaries are going to be subject to that court's approval. I'm sorry, authority. Listen, it's 2:00 in the morning and I'm reading my notes and I don't have my glasses on and I'm so tired, but I'm trying so hard to get this out for you guys. It's for their authority. They're subject to their authority. For the convenience and to kind of make understanding the population, I don't know how to really say this. So state lines have been used as those district boundaries, okay? So, but there's no connection like between the state authority and the federal authority. Lord, I should probably just go to bed. Just because of setting like those particular boundaries. Now, states with substantial populations and really substantial litigation too, they will have more than one U.S. district court. And those are going to be divided by county lines simply for convenience within the state. A district is going to cover like a wide geographical area, and that can be divided into divisions as well. And those will operate as branches of a district court. They will have, buildings in each division to make the court more accessible to the citizens. Some federal courts are set up to expressly handle like certain types of cases. So, like specific types of claims that get made against the government have to be filed with the U.S. Court of Federal Claims. Claims that involve tax will be tried in the U.S. Tax Court. Then you have the Court of International Trade that's going to hear disputes that are involving international trade agreements. You have the U.S. Court of Appeals, and this is for the armed forces. Like for the armed forces, they will have the final review on any kind of military tribunal. And those claims have very specific and often complex legal standards that are different than like a normal case. A party to a lawsuit who is not satisfied with a U.S. district court, again, they can appeal to a U.S. court of appeals that is designated to hear the case that is appealed from that particular U.S. district court. That system of pairing the specific trial courts with a particular appellate court is going to allow the appellate court to create legal standards to be consistently followed by that designated U.S. district court that's subject to that appellate court's authority. So U.S. courts of appeals, they were originally established to make appellate review faster and easier and like more accessible. And currently there are 13 courts. 11 of them are located across the country, and they are identified by numbers. And like the first, U.S. Circuit Court of Appeals. And then we also have the U.S. Circuit Court of Appeals for the District of Columbia, which is going to hear cases that are like originating out of D.C. And then we also have the U.S. Federal Court of Appeals, which is going to hear cases from special federal courts, such as the U.S. Court of Federal Claims and the U.S. Court of International Trade. So let me think what else I want to add. So the U.S. Court of Appeals, they are the court that is going to be most responsible for establishing the legal standards. And the Supreme Court, like they issue opinions that control in any situation, but the limited number of cases that are heard and the opinions that are issued basically limit the number of legal standards that are established by the high court. Okay. So like the U.S. district courts, like the physical limits of authority of each U.S. Court of Appeals, again, they're defined by the geographical boundaries. And each circuit court of appeals that's responsible for handling those appeals is also coming out of geographical boundaries. But the U.S., it's over everything. No U.S. Court of Appeals, it has authority over another. Each is going to be independent, and they're only accountable to the U.S. Supreme Court. So when different courts issue conflicting legal standards, the Supreme Court may accept one or more of those cases to decide basically exactly the legal standard and what it should look like. And that's going to eliminate any kind of inconsistency that is going to arise from, those different rulings in those different circuits. Then you have the Supreme Court, who is the final authority on all matters in the federal jurisdiction. This court cannot overrule Congress or the president unless the legislative or executive branch has in some way like exceeded or violated the authority that was given to that particular branch by the Constitution. And then that action has now been, challenged in court. The primary court of the Supreme Court, the primary court. See, I told y'all I should go to bed. The primary function of the Supreme Court is one of review. And the court reviews cases from federal courts and in some cases from the highest state courts if they have constitutional issues or one that includes the government as a party. But the key element in authority of the Supreme Court is that there has to be a federal issue at stake again, or there has to be, whether it's the parties involved or like the constitutionality of state or federal law. The Supreme Court does have limited original jurisdiction, and these are going to be cases involving original jurisdiction that they're not appealed. Okay. They're filed in the court for the very first time, and they're limited to certain types of situations that are listed in Article 3 of the Constitution. There's two common methods for obtaining review. The first is by right. So certain types of cases are automatically entitled to review by the Supreme Court if the person or the party desires for the Supreme Court to look at it. And the court will review the case as long as like the procedural rules for filing the appeal have been met. The second and probably the most common is known as certiorari. And that is going to, that describes the authority basically of the court to accept a number of cases for review where there is no right, but where it would serve the best interest of justice to have the court make a final and ultimate determination on the legal standard. Another thing I want to point out is that another determination, like a factor for determining whether or not to grant certiorari in a case, is when the decision that was offered for review involves constitutional rights. So the ultimate goal of the court is to ensure that the Constitution is going to be applied fairly for all persons. So when the court declines to accept a petition of certiorari, the practical effect is that it accepts and indirectly affirms the decision of the U.S. Court of Appeals. Now, in rare cases, a U.S. Court of Appeals may certify a question in which the appellate court would specifically request the Supreme Court to resolve like a pertinent issue on which like various U.S. courts of appeals are, divided. But totally independent of the federal courts or the state court systems for all the states, and each one of them also have their own legislative, executive, and judicial branches that in a lot of ways parallel the federal government. Every state has, a judicial system, and some disputes, must involve like acts or occurrences that are controlled by state rather than federal law. The law may be a case law or state legislative law, but no state court is bound by the authority of a court from a different state. Nor are they obligated to follow like the rulings of an equivalent court. States use two basic judicial structures, and actually, hold on. I think my next slide is about states. Just kidding. It was to show you this. So this is what our federal system looks like. And these are all of our judicial districts. As you can see, we are in the 11th district. Look at that. I was right. So state courts, they have two basic judicial structures. They have a 2-tiered and a 3-tiered. Now, the 3-tiered is comparable to that of the federal system, but the tiers are, a court of last resort. So the highest, the Supreme Court of the case. Actually, you know what? I can't say a Supreme Court because New York calls their trial court the Supreme Court. If you've seen Law and Order, then you know exactly what I'm talking about. But we don't have that here in Georgia. We call ours Superior Court. And then it goes to the appellate court, and then it goes to the Supreme Court. But I digress. So this is where you have the court of last resort or the highest court of the state. Then you have the intermediate appellate court, and then you have the trial court. Now, in the alternative, you have the two-tier system, which has only one appellate court, and it's the Supreme Court. And then you have a bunch of like various trial courts. But because of like the increase in litigation in most states, um, there's leaning toward a three-tier system, if not already using a three-tier system. I'm trying so hard to get you guys through this, and I promise I will not ever test you on this. This is just your background information. Um, so the term district court and circuit court are used in some states the same way that they are used in the federal system. Other states reverse those titles, and some states use things that are entirely different, like I just said that we do. So people who are not trained in the structure of the legal system can often be very misled as to like the importance of a judicial opinion by attaching more weight to the decision than is warranted simply because of the name of the court that gave the opinion. Hint, hint, New York. But because the trial courts of the states handle more cases than any other level of state or federal in the US legal system, they have to be organized to process like the slew of cases that get filed every single year. And more often than not, the state courts will divide the time of various judges by the type of case that are getting filed. So the various divisions are going to operate together to create like the trial court level. But the trial courts within that state can also be broken into like a family court or whatever. And then they can also be broken down by counties, which are, of course, divided into smaller geographical regions. And again, it's about providing a way for guaranteeing that people have, reasonable access to the courts. So let's talk a little bit about the process of legal analysis. And the this skill of applying like past experiences to current or foreseen circumstances to determine probable outcome is a skill that we need. So, like for attorneys, the skill lies in the ability to look at these past situations that are within the legal system and try to predict the likely outcome of their current case. And again, no two cases are exactly alike, and legal issues are not always simplistic. So legal analysis is performed at a much more complex level. Okay. So it's necessary to identify all of the relevant like similarities and differences of facts, like the law of jurisdictions, the parties, even apparent like attitudes of the judges and like potential juries. But each factor is then evaluated in terms of like their significance and their impact on likelihood of a similar result in the case that they're using. These analytical skills, they are also directly supported by like the training and the skills that are needed to identify these cases, locate them, the facts, the law, all of that stuff. And it's rare that both legal research and like the investigation and discovery of facts is going to produce little to no result. Okay. It is more often than not that attorneys are going to have to sift through like a huge amount of information and either retain the facts as significant or like toss them aside as unimportant or inapplicable. And that process in and of itself is legal analysis, like at the base level. Now, a more complicated task of evaluation is the applicability and significance of what remains, and that becomes the focus. So you're at this crucial point when the lawyer determines, the likely outcome of the case, right? And they do that by applying the legal principles that have now been like analyzed. And that determination is now going to guide the case in terms of settlement, trial tactics, strategies, like whatever, and even whether to appeal any kind of unsatisfactory results. But the legal analysis is going to allow a judge even to resolve a dispute in a way that is consistent with modern balance. And it's going to allow the lawyer to like advise the client as to like the appropriate um, course of conduct based on these past experiences of these people who were in, similar situations. It will allow the paralegal to know what information, will be necessary when interviewing a client and preparing legal documents. Um, Sorry, I am so tired, but I am determined to get through this. Um, so legal analysis, okay, is performed with in respect to like statutes and administrative law and cases and stuff like that. And the process of analyzing the different types of law is going to vary somewhat because the format is a little bit different between the laws that are generated for the general public and then laws that are generated for legal standards that are applied to specific parties. But the desired effect is still the same. It's to determine the applicability or the non-applicability of the legal standard to the case at hand. Now, of the various methods of legal analysis, case analysis is the specific method of legal analysis of the past judicial opinions and their impact on the current situation. You're going to look at the similarities and the differences between the past case and the current case. And that's to give you insight with regard to whether the outcome should be similar in the current case or is it very different. But because it's so frequently used, there's an organized system for, publishing and arranging the cases is necessary so that the cases on specific topics or from particular courts can be easily accessed. So published cases are predominantly appellate for a lot of reasons, but the trial courts are generally the lowest court of judicial authority. So a trial court opinion doesn't need to be followed by a judge in a subsequent case. The decisions are going to be applied to a specific case in a particular locale. However, I should say, when faced with a similar case, trial courts are under an obligation to either follow a legal standard or interpretation from a higher court or make it clear distinction as to why the outcome of the case should be different. And the appellate court's distinction as to why, appellate courts, let me back up. The appellate court's opinions do have to be followed by trial courts. And these are subordinate to the authority of the appellate court that issued the opinion. So it's binding. It has to be done. These appellate decisions are usually rendered by a panel of several appellate judges rather than the single trial judge. And again, we're looking at their collective, wisdom that's respected in the legal community. But the judicial opinions are published and they're published chronologically. And that means as they're handed down by the courts, and it's done in a series of different publications. So sometimes the same case is going to be put in more than one publication, but each new volume in the publication is numbered consecutively, and it's going to contain the most recently issued opinions. And sometimes the format changes are made, and there's a new series of volumes that started to like reflect the updates. But with each new series, like the numbering of volumes is going to start over. And that series and volume, is going to, the renumbering there, it's going to signal that change in format. So that's something that you would have to look for. If it doesn't signal, a change in like the chronological publication or anything like that. Just like the rest of it. Anyhow, so once a particular group of appellate courts opinions have been collected for the inclusion, they're published in a reporter, by the way. That's what they're called. The courts will continue to have their opinions published in that particular publication. So in that way, if you are frequently looking at research in like a specific jurisdiction, then the opinions from that appellate court for that jurisdiction is going to be where you're going to go, and they're going to be all kept together. Now, regardless of the judge or the jurisdiction in which, like, from where the opinion came, nearly all complete judicial opinions contain the same essential elements. And that does help with I think a more I guess I would say a more thorough understanding of the legal opinion and like the reasoning behind it. But it also gives you a way for like an easy comparison of similar legal issues that arise. Okay, so the I'm trying to look at my notes. The initial step here is going to be analyzing like the meaning of the case, and that's to know the elements of the judicial opinion. So the analysis can be renamed or reorganized in any single, pattern whatsoever, but it's still going to contain the same like fundamental elements. The term case brief describes a synopsis of a judicial opinion, and the common purpose of those is to just to give like a determination of the effects of a previously issued judicial opinion on a current situation. So to accurately kind of make that determination, one would have to like examine each aspect of the case and decide whether the case is sufficiently similar to the current situation to create the likelihood that the same legal standards would be applied in the same way today. The case brief's purpose is to identify like only the points that are pivotal in the decision, right? And consequently, I'm just going to pause. I'm going to get through this part, and then I think I'm going to nap for the rest of this. But it has to be sufficiently similar to the current situation to create a likelihood that the same legal standards would be applied in the same way today. Okay. So a case brief's purpose is going to be to identify those key facts. And it contains two types of facts. You have the occurrence facts and the legal facts, which can also be called procedural, by the way. Occurrence facts are the details of the circumstances that initially gave rise to the lawsuit. So you have two questions that can be asked about each fact when deciding whether or not that to include that fact, in a brief. Will exclusion of the fact, prevent like the reader from understanding the general premise of the case? And two, was that fact, somehow pivotal in the outcome of the case? And the legal facts they're what took place. And that's once litigation started. And like it'll chronicle the progression of the lawsuit. So the only real legal facts usually necessary in a case brief are those that tie directly into the basis for the appeal. Okay, what ultimately prompted the ruling and the subsequent like judicial decision. Okay, now there are always exceptions to the rule, and that is when I guess less than absolutely vital information should be included. Okay, and sometimes these cases will, when you have otherwise like ordinary information, but it has an impact because of the result of that particular of the particular circumstances of the case. So although like more like, I don't know how to say this. Hang on, let me think. Much of the information that you are going to have is more often than not kind of like the backdrop of the case, okay? But sometimes it can influence other facts or legal issues in the case. And if so, then it should be included, all right? And the appellate courts that publish like the vast majority of these judicial opinions, like they don't serve the same function as the trial courts. Um, the ultimate legal issue in a trial court is one of, guilt or innocence. Are they liable or are they not? In the appellate court and the subsequent like published opinion, the issue is usually about like whether something inappropriate occurred in the trial court that somehow prevented the court from a proper finding on the basis of guilt or innocence, liability or not. But again, going back to that thing about how there's no two cases that are exactly alike, there has to be some room for the court to consider and apply the law it interprets for a given situation. So, likewise, no two juries. You're never going to have two juries that are identical in makeup, or in the way that they interpret, any kind of evidence. And because the US legal system places such a high value on the ability to have questions decided by fellow citizens, your jury of your peers, um, there's a significant respect that's given to them and that's given to their reasoning on the jury as to why a specific verdict was reached. And so the outcome is that both judges and juries, they are kind of given a certain degree of discretion for, their particular roles. Now, I said I was going to go to sleep, but I swear to you, I'll end up losing my spot on this. Um, so the appellate court, they examine whether or not, this grant of discretion, like, has it been abused in a way that the result of the case has been clearly and unequivocally contrary to those existing principles, right? Those principles of law and whether or not any justification exists for the deviation. And one method that can be helpful for those with less experience in identifying the legal issues is to read the opinion and then complete the following statements. Just like write these down on a piece of paper. The first one is the appellant alleges that the trial court erred or abused its discretion when blank. Okay. So the appellant alleges that the trial court erred when they gave this particular jury instruction or when they failed to suppress evidence. Or you got the question before the court is blank. So without exception, though, the judicial opinion will make some kind of reference to the legal issue. And I actually have a document that I use for like teaching this. I have a Facebook group that I teach this kind of stuff in, and it'll kind of show you where everything is. And I'll actually show it to you guys. You'll have to remind me though, because I will forget. But it does make a reference to this legal issue. And sometimes it's a part of the like resuscitation of legal facts, or sometimes it's in a discussion of the task that's before the appellate court. But the decision in a case is going to be based on some kind of existing statement of law or wisdom, right? And the court is going to use that statement as authority and apply it to like the occurrence and the legal facts of the case that's before them to determine the answer that needs to be addressed before the court. And most often, the court will use an established legal standard as authority. It's not always the case because sometimes judges will apply an opinion of a scholar, but that is a private opinion and not law, okay? And by incorporating such opinion into the legal opinion, the private opinion becomes the legal standard in that court. And in a case brief, one should indicate, the source of law, the legal principle that's used to determine the case. And just as important, like the actual principle um, should also be stated, because the source of law is the legal principle. Um, so when analyzing like the effects of the case, or of a case rather, I should say, it is necessary to know like not only like the source, but also the content of the legal standards. So you have to like seek out those principles to like address the issue at hand. Um, Trying to think. The court will give an explanation regarding like why or how the legal standard applies to the facts and the issue of the case. And it is impossible to predict the effects of a case without understanding like the reasoning of the court in the judicial opinion. Okay. So, unless this information is included in the case analysis or the brief, then you can't know, or you couldn't. How can I say this? One couldn't not determine like whether the same legal standards would apply in the current situation to the current facts and issue. And I swear to God, all of this stuff is going to make sense as we start going through this. One of the reasons that I don't like teaching all of this up front is because I weave it into every section that we were going to be going through. So I swear to you, it'll make sense. But once the facts, the issue, the law, and the rule have all been determined, then the case brief can be used to compare the case with other situations of similar facts or issue. And then one should then, kind of determine whether or not those similarities are strong enough to create a likelihood that the same legal standards would be applied in the same way in the other situation. Statutory analysis, administrative legal analysis, these are much more straightforward. Statutes and administrative regulations, they are more broadly written and they do not generally or they don't generally provide like detailed discussions of exact case scenarios. So those types of law will only be applied when various conditions or, elements have been satisfied. Trying to think what else I want to tell you. The specific elements of a statute, they are rarely given in the format of like a laundry list. Like they are written most often in narrative form. So one sentence is going to include multiple elements that must be satisfied for the statute to apply and then to indicate a result. And again, you're going to learn all of this in detail because we're going to be going through them, especially when we split off into the areas of law, which will start with torts. And I think we do that the week before midterm. So that's always my favorite part. I love when we get to that. But anyhow, you have to have you have to kind of you have to take care, when you're reading the statute and trying to identify that exact meaning of each element based on the language that's used, because the words that get used are and or must and may, and those can completely change the outcome. Because and like if you have a list of 3 things, it's like, I know this isn't exactly like a law, but it's like go to the store, get some food, and come home. That means you have to do all 3 things, right? Go to the store or go home. Now you only have to do one of those things. Even if you have go to the store, get some food, or go home. Again, you don't have to do all 3 things. You just have to do one of them. So and or are kind of like that. Now, the same thing with like must or may. Must means that it's mandatory. Okay? May means that, if you want to, like if it applies, so like if you must do something, it will say must. So just remember that it's mandatory. When you are looking for applicable authorities, the key is going to be to compare and to distinguish. Okay. So when it comes to the judicial opinions, like the information that is contained in them is going to be closely compared with the current facts and issues. So legal standards should also be compared in terms of like their applicability to the current case and the degree of influence that that authority should have. And I'm trying to think. It should also have any kind of precedents, cited legal standards, all of those things that the court and the current lawsuit could use in making a determination. Again, statutory analysis, this requires a look at the facts of the current case to determine whether it's addressed or not in the current statute. If they are not, then there would have to be a determination made on the overall applicability of the statute to the case. If it does apply, then what result? What result does this analysis indicate? If it doesn't, apply because there's like an absence of facts to satisfy the elements, then you have to be prepared to explain how the statute can be distinguished from the current case. And that's pretty much it for the court's part. So now let's switch to legislation. And a primary source of U.S. law is legislation, and it's enacted by the federal legislative branch, which is known as Congress. And the judicial and executive branches are the ones that will act in response to actions that are already taken by the legislature. Now, remember that Congress has the power to raise through taxation the revenues that are used to support the governmental functions. They can determine the manner in which those revenues are to be spent. They can regulate commerce. That includes the production, sale, transfer of interstate and international commerce. They can raise and support armies, declare and support wars, and they can establish such laws as necessary and proper to achieve their congressional objectives. Now, this broad authority vests in Congress to the power to pass virtually any legislation that is, 1, constitutional, 2, will facilitate the orderly operation of government, and 3, will protect the constitutional rights of the citizens in such matters like health, safety, welfare, and personal freedoms. Now, the legislative branch at the federal level is a bicameral system, so it's a two-part body, and that is provided for in Article 1 of the Constitution. The House of Representatives consists of people that are elected based on the population in geographical districts. So this component of the legislature is going to guarantee that all people are represented the way, regardless of whether they live in a heavily populated area or a small rural district. The Senate is comprised of 2 senators from each state that's elected by the voters, and the body of the Senate it guarantees that all states are represented equally, regardless of their size, their population, or their economic strength. Going back to the House of Representatives, they're elected every 2 years. You have to be at least 25 years old. You have to have been a U.S. citizen for at least 7 years, and you have to reside in the state that you wish to represent. The number of representatives for each state is based on the census, and that comes out every 10 years, and that shows the population of the people. With each census, as population moves and increases, the number of representatives for each state will also vary. Constitution guarantees there to be at least 1 representative for each state, though. The Senate they're elected to 6-year terms. They are elected from various states in staggered elections. So every 2 years, 1/3 of the seats of Senate are going to come up for election. They have to be at least 30 years old. They have to be a citizen of the U.S. for at least 9 years, and they have to be a resident of the state in which they are elected to represent. Now, the Senate and the House of Representatives, they function on a separate but related basis. So to kind of avoid like the duplicity of work, they have joint committees that are formed, and that has members from both the House and the Senate. And they work together to draft the laws that will hopefully meet the approval by the entire Congress, which we know that that doesn't happen a whole lot. But these laws, they will proceed individually through the houses for, whether they get passed or defeated. But to try and enact these laws, get the approval, required by the majority of both houses. So, in general, legislation serves three purposes, with the particular purpose that a statute serves strongly influencing the statute's like content and scope. So, a primary purpose of the system of government is to provide laws that will protect society from what is unsafe or what is unacceptable to a majority of the citizens. So laws that serve as this protective measure will come in a variety of forms and will address, many subjects that affect the order and members of society. Now, protective laws are designed to set forth what people are entitled to expect as citizens of this country. They also will protect what are considered to be the rights of the people to a safe and reasonable environment in which to work and to live. Now, shifting gears a little bit, a common misconception is that the U.S. Constitution and its amendments expressly guarantee a right to privacy, and that's not true. In an attempt by the courts and the legislatures to kind of uphold the various rights that are expressly guaranteed, the right to privacy has been inferred as, kind of a part and parcel of a lot of these fundamental guarantees. Let me think. A remedial statute. That is one that creates an alternative action or like a means to enforce a right. And that type of statute corrects existing law, or I should say, or remedies. It's going to remedy an existing grievance. So as this remedial statutes are designed to cure something, okay, that's already gone wrong or caused an injury. So an example would be like the 13th Amendment to abolish slavery and the 18th Amendment's repeal of prohibition. Now, at the state level, there is a familiar example of these kinds of statutes with state workers' compensation laws. And every state has enacted laws that provide that the employer will be responsible for any costs that are associated with injuries of an employee if the injuries occur while the employee is performing duties of their employment. So the workers' comp laws are examples of both protective and remedial statutes. On one hand, the statute may set out the right that the citizens are entitled to enjoy, which is a safe workplace, right? But at the same time, the statute may correct a situation which was dealt with ineffectively by the legal system or change a law that was considered unfair, by the majority. A third purpose of legislation is to ensure that protective and remedial statutes are available and applied to all citizens in the same way. And these are known as your procedural laws. And they give specific directions on everything from how to initiate a lawsuit to how a trial is going to be conducted. So their true purpose is to ensure that everyone gets the same basic rights under the legal system, or so they say. We can argue about that one day too. Now, the basic legislative process has remained the same in the federal government since 1787, and that's when the U.S. Constitution was enacted. Article 1, Section 7 is quite specific, on this point. So when a proposed law is introduced to the legislature, it's called a bill. And the Constitution requires that revenue-raising bills be initially introduced in the House of Representatives. Other bills can be initiated in either the House or Congress. So a bill is sponsored by a legislator who introduces it. And when the bill is formally proposed as legislation, it gets registered and assigned a number. And often the bill is known for the name of the legislators who have introduced it. So, for example, you have the McCain-Feingold Act. And officially, however, the statute is referenced in publications, though, by its assigned number. So, House Bill, blah, blah, blah. And once a bill has been introduced, it gets assigned to the appropriate committee. And it's for consideration of its contents, its potential, ramifications, as law, and in some cases for revision. Now, after the committee hearings, the bill then gets presented to the originating body of Congress, which would be the House of Representatives or Senate, and that's for a vote. And the bill must pass by a majority vote before it can be sent to the corresponding body for consideration. And before a vote, the bill is discussed and debated by Congress. So at this time, changes can be made to the language of the bill. And often these changes are necessary in order to gain the approval of enough people to pass the bill. If it succeeds the majority vote of where it began and which house it began, it then moves to the other body. And if it passes in that body, it's then forwarded to the president for either, approval or disapproval, veto, essentially. And after the president receives the bill, under Article 1 of the Constitution, the bill has to be acted upon within 10 days, Sundays excluded. So if nothing else is done during this time and Congress is still in session, the bill automatically becomes law. If Congress is not in session, then it becomes a pocket veto. If the president signs it, it becomes law on the date indicated by Congress. If the president returns the bill to the House where it originated, the bill's vetoed. But once a bill has been vetoed, a second vote can be taken. So if each body of Congress approves the bill by at least 2/3 majority, rather than by the original simple majority, then the bill becomes law regardless of the presidential veto. Okay. Another type of bill has the sole purpose of repealing an existing law. But nonetheless, that type of bill is assigned a number, and if passed, it gets published in place of the law that it reverses. An amendment has to pass both houses by 2/3 majority rather than the typical simple majority, and the amendment must then be approved by 3/4 of the state legislatures before it can be ratified and become a part of the Constitution. Lobbyists, let's talk about them. So lobbyists represent groups of citizens or industries that have a special interest in certain bills. So if a proposed bill is going to somehow substantially affect a group of people with certain interests, right? Then the group would hire the persons to lobby with the legislatures in order to persuade them to vote in a particular way on the bill. And the term originates from the early days of government when those people would actually wait in the lobby in order to be able to speak with, the members of Congress. They're critics of lobbyists. They say that people, that a few people unduly influence the legislators. And, they're supposed to represent the majority of the people. And proponents will argue, that lobbyists, in fact, they are representing those people who stand to be directly affected by this legislation. And that lobbying is the practical and effective method, by which to get these opinions heard, with the legislators. Now, I don't know that that's true. And again, that's something else that we could debate one day. Congress does meet for several months of each year in order to consider proposed bills. And those meetings are called sessions. So each annual session is numbered consecutively. So like the 85th Congress, whatever. And after a full session of Congress has been concluded and all bills have, and all laws passed during the session, they will take the collective name of session law. And then session laws are published in the statutes at large. And each session law is then assigned a public law number that represents the session of Congress in which the law was passed and the chronological order of the law in relation to other laws during that same session. That was just a whole bunch of words. I'm surprised I got that out. So each session law, it's identified by this, public law number until it can be incorporated into the publication of all statutes. And that's organized by subject. And this process of incorporating, the public law into existing law code is known as codification. Now, the United States Code, this is a comprehensive, collection of current federal statutes. And the U.S. Code is located in multiple bound volumes, okay? And the method by which the volumes are organized enables the statutes to remain current in light of constant change, okay? So all of the laws are divided by basic subject known as a title, so like banking. They are then arranged in alphabetical order. And then each law within the title or the subject, like banking, it's then assigned a section number, okay? And that allows for future revision of organization of the laws. If one law exists and is later amended, then that amendment's going to be assigned the same number as the previous law. What else did I want to tell you? Let me think. Each title is going to contain a table of contents that's listing specific sections of the title and the descriptive headings for the sections. And the statutes also have an extensive subject index, which is supposed to make them, more accessible. But with regard to the publication of the federal statutes, and there are two types of publications that are commonly used. The first is the code, and then the second is the annotated statute. And that has a brief description of judicial opinions that will interpret that particular statute. And this is literally here, just so that you can see the process in which something, how the bill flows. Pause to read. So the last thing we want to talk about here is the legislation and judicial review. And many times, people will disagree with a court on one of two common issues as it relates to the statutory interpretation. The first is whether the statute should even be applied to the particular situation. I know I've seen it many times, especially on social media. That's not what they should have been charged with, or that's not this. Give me a break. The second is how the statute should be applied to the specific circumstances of the case. Okay, so when examining a statute, one should first break it down into each element that has to be satisfied for the state statute, or for the statute to apply. Okay. Then you have to kind of compare the elements to the facts of the particular case. If all of the elements are substantially met, then it is probable that the statute would be considered applicable. Now, sometimes it's not apparent until a law gets put into effect that the law violates, constitutional rights of a citizen. And if those rights are violated and the citizen brings a claim to the courts, then the court has the authority to overrule the statute in favor of protecting the person's constitutional guarantees. There's a rule. Your constitutional rights end where mine begin, and vice versa. So we're not supposed to be trampling on, each other's. But so this is the only circumstance where a court can invalidate the action of the legislature. Remember that the U.S. Supreme Court has the authority over Congress, as does the High Court of each state over its legislative bodies. And this overruling rarely occurs, but when it does, the law is rendered ineffective and it can no longer apply to the citizens. One last thing I want to add is that a final role of the courts with respect to the legislature is that it serves as like a quasi advisory role. So from time to time, the courts will indirectly express an opinion through the language of case law as to what the law should be. So it's not within the court's authority to write the laws that will apply, but they can surely go hint, hint. So, Article 2 of the U.S. Constitution establishes the executive branch. It tells how the president and vice president should be elected, like their terms of the office. Section 1 also contains provisions in case the president doesn't complete the term. It specifies like who can run for president, tells the timing and like the method of the elections and stuff. The second and third address the authority and responsibilities of the president. And then Section 4 lists the offenses for which they can be removed from office. That includes the vice president and any other officer of the government. Now, in 1804, Section 1 of Article 2 was amended by the passage of the 12th Amendment. And that slightly altered the process of the electoral ballot and the election of the president by the House of Representatives in the event that no majority was reached by the Electoral College. Now, under the original Constitution, the person who had the greatest number of votes in the House of Representatives, and that's assuming that no majority was reached, in the electorate, they would assume the position of president. And then following that, the person with the greatest number of votes in the Electoral College, other than the person who was elected president, would be the vice president. So if there was no, one person with a majority, then the Senate would elect the vice president in a manner that was similar to the president. Of course, an obvious difficulty with the original process was that the person with the second greatest number of votes would automatically become vice president. And I should say second greatest number in the electorate. That person could very likely have been the president's strongest political opponent. And that would make an administration of government very difficult given the opposing views of the two people. Like, could you imagine when Trump and Hillary, or Trump and Harris? I mean, there's such I don't know. It just seems like it would make it a really weird situation. But the 1804 amendment, the result of a failed majority now in the Electoral College would be 2 elections. So then the House of Representatives would elect the president, okay? And then rather than an automatic appointment of vice president, that person would be elected by the Senate. So you still have the possibility for an election of officials with contradictory views, but at least some thought could kind of be put into, a more positive combination maybe of the personalities. Now, in 2000, the popular vote was the closest election in history. And in addition to that, in some areas, particularly in Florida, it didn't reflect the number of people that were registered with the various parties. So the Supreme Court held that the vote would stand. And that decision then paved the way for the Electoral College, which followed the popular vote. And that controversy demonstrated basically, in the most powerful way, the importance of votes of the individuals and really the necessity for care of the people who are, running the elections. Let's see. I told you Section 2. Those are the president's powers. So the president, they can negotiate treaties, appoint judges, and other cabinet members, things like that. They can convene Congress, grant pardons and reprieves, appoint ambassadors, command the armed forces, all that stuff. Specifically, the president has a great amount of latitude when it comes to establishing, maintaining, and ending foreign relations also with other countries. And on occasion, that authority covers a military action as well. It's a more of an emergency type situation, but it can still be done. But the power to declare war is vested still with Congress. Um, President's powers can be checked by the U.S. Supreme Court. Um, the president also has the enforcement power over the laws. So the federal law enforcement agencies, they are overseen by the executive branch. That's all your three-letter agencies. Trying to think. The president also appoints the attorney general, who serves as counsel for the executive branch on any kind of matters of the enforcement. But the bulk of the powers, they come from one small sentence near the end of Article 2, Section 3, and it says, "He shall take care that the laws be faithfully executed." So that statement has been expanded to create executive authority to oversee administrative law, which is one of the principal sources of law in the United States. The president cannot create administrative law like directly, but they are responsible for supervising like the activities of any kind of federal administrative agency. So a similar process is going to occur at the state level too, by the way, with their executive branches and like their state agencies. But the creation and the operation of these agencies, well, I'll tell you in just a second. Let me wrap this other part up. So originally, the role of the president was, kind of similar to like a head of state. And the duties were, serving as like the physical representative of the nation, the central figure, the face, the one, that citizens are supposed to like unite behind them. And, who, like other nations, when they think of you, they think of, your figurehead. And a significant duty was the negotiation of treaties with those other nations. But they had limited travel capabilities. They had no form of, rapid or like mass communication. And they also had very large rural populations that were separated from other countries, by ocean on three sides. And so the early presidents had few demands placed on them in comparison to what the presidents do now. Now, following the Civil War, a primary like post-war objective was to bring the nation together for the sake of the citizens. And that was to signal to the other nations that the U.S. was not weakened and subject to intrusion. About that same time, you had methods of transportation that were advancing with, railroads now extending through the country. You have maritime travel taking place on both rivers and oceans. You have telegraph lines that had made communications to most places possible. And those advancements and the need to unify, caused a change in the direction of the presidency. So the president became kind of increasingly involved in communicating with and representing the people of the nation with respect to the other branches of the government and other nations. Now, during the 20th century, the president worked with the other branches of government to keep, we'll say the nation kind of strong and independent, right? And we have these technological advances, and there was a huge increase in population through births and immigration. And it required extensive legislation and governmental supervision to protect a largely uneducated public. And so the result was the creation of a lot of administrative agencies within the executive branch of government. And it became the responsibility of the president to oversee the agencies in addition to the duties that they had already undertaken. And as time passed, the trend continued. And by the end of the 20th century, the president was involved with the actual representation of the population as any other element of the government. All right, this is the last bit, and I promise. The administrative agency has the basic role to act as a liaison between Congress and the people. They explain what Congress means in particular, like statutory language. They clarify it, they define terms, and ultimately, um, you know, under the supervision of the executive branch, they help enforce the law. So Congress first passes law that enables the creation of an administration agency or administrative agency, I should say, and then passes additional statutes that have to be enforced. So the president staffs now and oversees the administrative agency as it clarifies, defines, and enforces the statutes that were passed by Congress. And a lot of those agencies are, controlled by the 15 departments of the executive branch, like the Department of Justice controls the FBI. The Treasury Department controls the IRS, that type of thing. So the heads of the executive departments serve as members of the president's cabinet. Hang on. Now, the day-to-day operation of the administrative agency is largely within the control of the executive branch. And again, the agency is created by Congress under Article 1. So the statement in Article 1, Section 8, paragraph 18 specifically, that statement has been interpreted to allow Congress to enact laws that allow the government agencies to clarify the laws through regulations and administrative decisions. So the president's power to appoint federal officers will allow the executive branch to staff these agencies, and the executive duty to see the laws, that to make sure that those laws are faithfully executed still lies with the president. The authority to oversee the agencies as they enforce the laws, passed by Congress it still lies with the president. The administrative agencies, they've been a part of our legal system since the 1800s, and they can perform a lot of functions that Congress, for practical reasons, just can't accomplish. So these agencies offer a lot of advantages. Like they can deal with large groups of citizens and entire industries. They have the ability to respond quickly to like rapidly changing needs of an industry or citizens. Their staff members more knowledgeable about the specifics of an industry or like of a group of citizens. And they also can provide consistent and fair standards for, citizens and the industries. But before these agencies came into existence, Congress had to pass a resolution, saying that an agency is necessary to carry out the goals of certain legislation. So Congress had to determine that there was no other more effective way to make sure these goals were handled, okay? And that the goals of the legislation were enforced. So Congress then passed what was commonly referred to as the Enabling Act. And that was a statute that expressly stated that the goals of Congress of a particular subject of legislation, the agency would be created. Now, early on, the delegation of authority to make rules with effective law was strictly prohibited by the Supreme Court. And as time passed and the needs of the country grew, the court relaxed its position a little to permit the administrative agencies to play a larger role in the legislative process. Now, they have never been allowed to create law, but agencies are permitted, again, to create regulations. And these regulations are intended to promote an efficient, responsive, effective government. Now, the chief concern of the courts at this time was, with the respect of the creation of these agencies, was that they didn't want the delegation doctrine to be violated. And the delegation doctrine is based on the premise that Congress cannot be allowed to give away any of its actual lawmaking power, okay? So Congress can only give up or delegate the authority to clarify and enforce the laws that were passed. So an agency that Congress had delegated authority to wasn't free to go and start making up original laws on its own. The only thing it could do was serve in the functions of clarification and enforcement. Um, so alleged violations of the delegation doctrine, they get reviewed, and typically first at the agency level and then at the courts. And in some instances, those reviews have proceeded to the Supreme Court, which it developed certain standards to contain the work of agencies like within their specific agents within their purpose. Okay. And one of them was the FDA versus Brown and Williamson. And this is where the Supreme Court ruled that the FDA, the Food and Drug Administration, that they could not regulate tobacco because Congress never delegated such authority to that agency. Then you have Massachusetts versus the EPA. And the court ruled that the Environmental Protection Agency was granted power in the Clean Air Act to regulate carbon emissions. So through the interpretations of the delegation doctrine, the Supreme Court has established, a few major criteria that has to be followed when it comes to the creation and operation of these administrative agencies. And any act that enables the creation has to be clear in its purpose with definable limits. If it appears like from the language of the Enabling Act that Congress doesn't, clearly state its purpose as an intelligible, principle to which the agency must conform, then that Enabling Act can be struck down and being, unconstitutionally overbroad. A second major criteria about the delegation doctrine is that the agency's enforcement of the law has to be accomplished fairly and openly. So if an agency fails to create a regulation that provides for the fair and open administration of laws, then the president and the agency have not received proper guidance from Congress. Let me think. Article 2 of the Constitution states that the president should appoint government officers. So agency staff members cannot be employed in any profession or agency or industry rather that the agency oversees, because that would not constitute fair and unbiased administration of law. There would be some kind of vested interest. The Constitution, according to the Constitution, those laws are to be enforced by the government and not by the private sector. There's a case that is from 1936. It's called Carter v. Carter Coal Company. And many of the regulations for the coal industry were discovered to have been created by committees of people that were employed at high levels of the industry. So the court found that was improper, when it came to enforcing the laws. And the president, can, however, ask people who are experts in their field to leave private industry to come work for the agency, but they can't, still be employed. The passage of the Enabling Act and the creation of an agency. So those have to be done in a manner that, at the very least, the goals of the statute have to be clear. The statutes have to be defined. They have to have definable limits. The methods the agency uses to enforce the statutes have to be fair and open to, all members of the public. And the enforcement of the statutes have to be accomplished by, officers of the government and not by people with private interests. Now, agencies were a part of the New Deal era. And that's when these agencies, they sought to aid the country during this time of economic recovery, when they're coming out of the Great Depression in the 1930s. And Congress increased its use of administrative agencies, and they cooperated with the president in using them to deal quickly with a lot of the problems that the nation was facing at that time. And in the years that followed, the courts became more involved in, kind of reviewing the efforts of the executive branch, to oversee those agencies. And that delegation doctrine, it had more and more stringent requirements, on the manner in which these agencies could be created and operated. So Congress responded to that in 1946 with the Administrative Protection Act, the APA. And I know you've probably written a paper in school that's APA style, not the same APA, of course. But this was used in addition to each agency's enabling act. And the APA included the necessary elements to satisfy the requirements of the delegation doctrine. So, since that time, the APA has been modified and it has been improved on more than a few occasions to make sure that, agencies, they're in compliance with the criteria that the courts have established under the delegation doctrine. The APA, together with the Enabling Act, it does provide for the creation of an agency as well as for the agency's, fair and efficient operation that it's supposed to be doing. Once the agency is staffed, its employees are responsible for organizing its administration and addressing the subject or industry that those particular statutes affect. Trying to think, I needed to tell you one more thing. The most prominent function of the administrative agencies is their authority to issue the regulations. Now, administrative regulations, those must be required to achieve like the goals of the Enabling Act or, other federal laws that the agency has responsibility to enforce. So all regulations, they have to be, they have to come from this legislation that's, formally enacted by Congress. So like if an agency holds a hearing and determines that a regulation has been violated, then the agency can impose, sanctions on the violator. Now, if an agency, wishes to issue rules, not regulations, it has to follow like specific procedures, and that's also set forth in the APA. Some enabling acts will dictate the precise steps for the agency and what they have to take to establish and publish the regulations for the public. And those formal rulemaking procedures, they do require, public hearings and the opportunity for testimony, the, other input from the public before, any regulations are actually put into force. But most agencies are also allowed to create rules through an informal process, and that's governed by a series of detailed requirements that come from the APA. Trying to think. Most of the agencies, they do have to stick to following those procedures when passing, rules. And so it's like the agency has to give advance notice to the public. And they have to lay out the basic terms of the rules and that it's proposing, to enact. And then at the federal level, that gets done in what's called the Federal Register. And that's a daily publication. And it gives that information about the actions of the Federal Administration Agency, or administrative agency, rather. See, it's already getting late again. The agency then has to give the public the opportunity to participate in the agency decision by allowing, the submission of comments and ideas and suggestions that, regarding the proposed rule. After the consideration of the public comment, the agency has to issue with the final rule, a general statement of the basis and purpose of the administrative agency that's supporting the rule. And after all those requirements are met, then the agency issues its formal regulations, and then they publish them for the first in the Federal Register and then into the Code of Federal Regulation, which is also CFR. You'll probably see that around. And that's where all, existing regulations are. But each agency, they're assigned a title that's similar to like a title in the code, and each regulation, it gets assigned a specific section, number, and it's placed in there with other regulations of that agency under that same proper title. So like, the code, an index of regulations within that title is also included. Uh, I think I'm pretty much finished. Actually, let me back up. So the APA does require to the APA requires agencies to review their regulations like periodically, and it also gives citizens certain rights with respect to the agencies. Now, citizens have the right of access to agency information if it pertains to the public, and a right to information that the agency has about them personally. So, citizens who challenge the authority of an agency to create laws or whatever to use a particular method, they're required to exhaust their remedies when they're challenging this. That means before they can turn to the courts, they have to first pursue every opportunity that they have to resolve the issue by dealing directly with the agency. And there are exceptions to that requirement, um, but it's very limited. Um, if the judicial system does become involved rather in a dispute between the citizen and the agency, it will consider whether the agency's authority was clearly defined, whether the agency's action exceeded the limits of the agency's authority. That's under the delegation doctrine. Um, Whether the agency, followed the proper statutory procedures according to the Enabling Act, and the APA and any other statutes, and then whether the agency's action, was conducted fairly and openly, and whether it violates any constitutional rights. And then that's pretty much it. President, they can specify the manner in which they want, laws to be executed. And that's all I have to say about this. This was already a really long lecture. So let me know if you have any questions. Bye.